All right, so good afternoon, everyone. Welcome to MBLS's Medical Debt Training, Legislative Updates and Strategies for Pre and Post-Collection Suits. Our presenters this afternoon will be Lindsay Muniak from a medical debt organizer from Debt Collective. The second presenter will be me, Asia Mallory, from the Consumer Staff Attorney at MBLS. And then our last and third presenter will be Mary McGesh Jordan, the Managing Attorney at Civil Justice. If you have any questions, you feel free to put your questions in the chat. I will be monitoring the chat. So we are good to start.
All right. Hello, everyone. My name is Lindsay Muniak. I am an organizer with the Debt Collective, which is a national debtors union working on various types of household debt to challenge those that we identify as unjust debt. And of course, medical debt is one of these. And I'm also co-chair of End Medical Debt Maryland, which is a statewide coalition of nearly 70 labor unions, community organizations, legal aid groups, including the Maryland Volunteer Lawyers Service, who have convened this webinar, and Civil Justice, Inc., who will be presenting in a bit, who are working to challenge predatory medical billing and debt collections practices. And we chose to organize this webinar because the legal landscape around medical debt has changed quite a bit in Maryland over the last few years. And we want to let everyone know what legal protections are now in place for debtors, in part because we can only ensure these protections are actually being enforced at the administrative level if attorneys and community leaders like those watching this webinar who are doing the work on the ground with medical debtors actually know that these laws and regulations are in place. Next slide, Aisha. And I just want to take a moment to acknowledge the many member organizations that make up the End Medical Debt Maryland Coalition, many of whom played critical roles in securing these new legal protections that we're going to be taking a look at today. And would love to continue building the coalition if folks are interested in getting involved. Next slide. So what has been driving these legal changes? I want to just sort of quickly acknowledge why it's so important for attorneys, for community-based organizations, for local leaders to be aware that they exist. And it's because, nationally, we are in the midst of a medical debt crisis. Recent estimates place the total amount of medical debt in collections alone somewhere in the range of $88 billion to $140 billion, which is, of course, a staggering number that actually doesn't even account for all kinds of medical debt that don't appear on credit reports that are used to call this data because they haven't gone to collections, because people have taken out loans, because people have borrowed money from family members. So this is really just a fraction of the total crisis. And a recent study basically identified that overall about a third of the country is actually struggling with unpaid healthcare debts in whatever form that may take. And of course, like other forms of household debt, medical debt disproportionately impacts Black households and communities, low-income communities, and creates these cycles of poverty that can be very difficult to escape from. The Brookings Institute, I guess now they're just Brookings, released a study last year that found that the vast majority of healthcare debt, about 80%, belongs to households with zero or negative net worth. So all of these factors have sort of been what's driven us toward pushing for more regulatory oversight, toward pushing for more legal protections for patients, for debtors. Next slide. And so this is just a sort of overview of some of the key legal and regulatory updates over the last couple of years, which we'll be going into more in depth in just a moment, and wanted to basically convey that what we're hoping to do here is offer a quick overview of the current legal landscape in Maryland around medical debt, and allow people to take away the following: what new medical debt protections have been put in place, a sense of maybe some of those that don't exist yet, which can come from knowing what's in place, and a read on some of the areas that we've identified as needing special care to ensure that these legal protections are actually being enforced and put into practice. Next slide. So this is the first bill that I want to take a look at actually precedes the formal formation of the End Medical Debt Maryland Coalition. It was introduced in 2020 by Delegate Robin Lewis and basically focused on financial assistance policies. And this legislation, which was passed, what the amended version of the bill does, or which I should say now a law, is increase the household income threshold under which hospitals need to provide free care to patients from 150% to 200% of the federal poverty level, excuse me. And so, where before, if any patient who had a household income of under 150% qualified for free care, now anyone with an income level under 200% of the federal poverty level does. And that's, it seems like a small jump, but really captures a huge number of people. And I think it's, as we're helping patients navigate the process of applying for financial assistance, it's important to be aware of these different thresholds. The bill also requires hospitals to offer patients a way to appeal the denial of free or reduced cost care. So if you're working with medical debtors on the ground, they apply for financial assistance, they're rejected, there has to be an avenue for them to appeal this decision. And I would encourage anyone who's working with people in this situation to really kind of continue pushing, not to be deterred by rejections of their applications. It also prohibits hospitals from using a patient's citizenship or immigration status as an eligibility requirement for financial assistance, which is, of course, hugely important for all of the undocumented communities who really need this financial assistance from hospitals and rely on it in a lot of ways. And I think that this is something that we've heard from our allies at CASA and other groups that are working with immigrant communities, that there's a real fear and continues to be a real fear of applying for hospital financial assistance policies, because of worries that it may trigger some sort of investigation into documentation status. And then it also required hospitals to offer their policy in any other language than English that a population speaks, that constitutes 5% of the total population in the city or county. So Baltimore City, I think, is the sort of city question here, or county where it's located. And so basically, we want, as attorneys, as community-based organizations are helping people navigate the process of applying for financial assistance, we want us all to be aware that these basic rules are on the books. Next slide. And then our really big legislative victory or legal victory is this law, which passed in 2021. It's been referred to sort of broadly as the Medical Debt Protection Act. And what this does is, I think maybe the most crucial components are it prohibits hospitals from requesting liens against a patient's primary residence. It prohibits hospitals from garnishing the wages of patients who qualified for free or reduced cost care. And of course, I, on the slide, added should have, because if a patient has qualified for free care and has actually been captured as a patient who qualifies for free care, they shouldn't have any debts to begin with. But it's another reason that it's so important to really work with people to apply for financial assistance, to determine eligibility and to secure that. It prohibits hospitals from charging interest or fees on debts of patients who received free or reduced cost care. Again, patients who received free care shouldn't have debts, but this is the language of the law. And it requires the HSCRC, which is the Health Services Cost Review Commission, which in Maryland is the regulatory body that basically has oversight over the hospitals, to develop guidelines for income-based repayment plans to be implemented by hospitals statewide. And that triggered a separate work group that worked on developing these guidelines, and we'll take a look at those regulations in just a moment here. I think another just couple elements of this legislation that are interesting for those of us who are trying to track where people are finding, their medical debts and collections most frequently, where people are being hit with the most hospital lawsuits. This bill required hospitals to submit annual reports to this regulatory body, the HSCRC, that highlight key aspects of their debt collection activity. So what the report sort of breaks down is medical debt collections by race and ethnicity, by zip code, by gender. And what we want to sort of establish there, which is I think what a lot of us are also sort of trying to establish in the field, is where people are finding their debt and collections, who is finding their debt and collections, how does the collections process fall unevenly on certain communities and not others. And it increased the window after an initial medical bill during which a patient can qualify for free or reduced cost care. So people now have 240 days to retroactively qualify for free or reduced cost care for medical services that they received at a hospital in the state. Next slide. So as I mentioned, the Health Services Cost Review Commission, this regulatory body, convened a work group to develop the income-based payment plans that were mandated by this bill. And those regulations are now in place. And they require all hospitals in the state to make payment plans available as an option to all patients. Again, this is something that, hospitals are required to make these available. That doesn't always mean that they're making patients aware. And so it's really important that anyone who's working with debtors, with patients who are struggling with the cost of healthcare, knows that this is an option for anyone. And the regulations state that hospitals cannot require any patient to make monthly payments that exceed 5% of whichever is lower, their federal or state adjusted gross monthly income. So really trying to kind of limit the ways that these paying off these medical debts, paying off these hospital bills are cutting into patients' monthly budgets. Hospitals cannot charge interest on medical debts that are owed under a payment plan by patients who qualify for financial assistance for what's sometimes called charity care. And they cannot charge interest on medical debts owed by uninsured patients. And sometimes the language there from the hospitals is self-pay patients under these payment plans. And then for anyone else, there's a window of 180 days during which interest cannot be charged. And so really making sure first that people know that these payment plans exist as an option, that they're mandated, and also making sure that we know what these payment plans actually mean concretely, what they mean that if you are working with a debtor who is being encouraged by a hospital to set up a payment plan amount of greater than 5% of their monthly income, you know that this is a choice of theirs, that this is actually not something that's necessary, that 5% is the highest amount legally that any hospital can ask patients to pay. Next slide. And this brings us to the newest of these laws, which was enacted earlier this year, and basically looked at the fact that there's a pattern here of patients who seem to have qualified for free care, for hospital financial assistance, weren't identified as having being qualified, either because they weren't aware that this was an option that existed to them, or because they were denied and chose not to appeal, or didn't know that they could appeal, I should say, and ended up paying into the system, paying their debts, despite this fact. And so with this legislation, which was introduced by Delegate Laurie Charkoudian, the same sponsor of the previous bill that we were looking at, what it basically achieved is that it required the HSCRC, the Department of Human Services, the State Designated Exchange, Office of the Comptroller, and the Maryland Hospital Association to work together to develop a process for identifying these patients and reimbursing them, these patients who should have received free care, but who paid into the hospital service system between 2017 and 2021. And Another component of this bill was that if this process that these bodies establish requires legislation for implementation, the regulatory body will make some recommendations. And as we'll see in just a moment, that seems to be the path that we're taking. Next slide. So the HSCRC has convened a work group that will offer input into the process of developing the process. So yes, this is actually the language that's used, but of reimbursing hospital patients who had paid for services when they should have received free care. And time is reserved at the end of each of these work group meetings for public comments. If you're interested in participating as a viewer and perhaps speaking during these public comment sessions at the end, you can attend these meetings on the work group on hospital refunds by signing up. There's a long registration link here, which I know isn't especially convenient, but you can also find it by going to the HSCRC website. And the next meeting is actually this coming Monday, September 19th from 2 to 4 p.m. And what's going to be important about this work group is basically that it'll craft again the process by which these patients who paid into a system where they had the right to totally free care, that they're getting that money back. And so for any attorneys or community advocates who are interested in seeing how this process unfolds, I think that there's also going to be a lot happening as these regulations and recommendations are developed, that'll be important for us to be attentive to as patient advocates and representatives. I would encourage you to check out the work group. And I know that this is a lot of dense legal language and dense regulatory information in a pretty short time span. But if you have any questions, please feel free to reach out to me. I know that my email will be at the end of this slide deck as well, but it's lindsay@debtcollective.org. And we really want to ask everyone to at least be broadly familiar with these protections that are in place so that when violations occur, we can identify them and ensure not only that the patient who encounters them is able to move past those obstacles and overcome a lawsuit or get their debt out of collections, any of these things, but also to ensure that we're reaching out to the HSCRC and other regulatory bodies, and that they're approaching these institutions where we're seeing violations and saying, look, what's going on here? And being sure that these protections are actually being put into practice. So with that, I will pass it back to you, Asia. Thanks so much.
Lindsay, there is a question. The question is, do these protections extend beyond hospitals to adult living facilities, nursing homes, and other institutions that accept public benefits but are also empowered to discharge residents for non-payment?
This is a great question, and I wish I had a different answer. I mean, the answer is that they don't. I think that this is something, just speaking broadly, I mentioned earlier that I am an organizer, and so this is something that we intend to fight for the expansion of protections like these. The reason that they only apply to hospitals in this case is because nonprofit hospitals, which are every hospital in Maryland that isn't government owned and run, are required by the Affordable Care Act to offer financial assistance to low-income patients. And this is in exchange for their tax exemptions by the IRS. And so there's a sort of legal leverage there that made it possible to pass these bills because this financial assistance requirement is already on the books. What we were trying to do here is basically strengthen the financial assistance requirements and ensure that they're actually being enforced and put into practice. And those financial assistance requirements don't exist for adult living facilities, for nursing homes, for other institutions like this, but they should. And so again, definitely not the answer I wish I could give, but I think that this is something that people are planning to really push for. I know that I am, and others who are in this coalition are. Thank you.
All right, thank you, Lindsay. All right, so the next topic we're going to discuss is medical debt and what to do prior and during collections. The first steps, if you are facing medical debt, is one, to check your medical bills for accuracy. Are the items accurate? Did you receive the treatment that they are, asking money for? Is this your correct name? Does it have your correct insurance information, your billing address? Like, just make sure that your medical bill is completely correct and that they are not seeking money for something, for treatment you didn't receive or your client didn't receive, or they're seeking treatment for someone else that may be at a different billing address, or there's just something wrong with the address. The other thing is you want to ask your provider for a plain language explanation for unclear items. Hospitals are supposed to give you a plain and clear explanation of all of your treatments and what you're there for. If they don't provide that to you, you can always feel free to contact one of, the advocates here that are presenting to assist you with getting that plain language explanation of the items on your medical bill. And then the next step you want to do is seek financial assistance options. If you don't know where to go, you can definitely call 211 for information and resources. They will get you started on your next steps on how to deal with your medical bills. So when you're seeking financial assistance, 211 will provide you with the information to contact your hospital, your medical provider, or the hospital in the area in which you receive treatment. You can go to that hospital, you can ask for their financial assistance policy. Then you want to complete the application. You want to fill it out completely and as accurately as you can. I myself, I'm always available to help clients or other attorneys help their clients fill out medical financial assistance applications. They can be very long and they can also be confusing for the patient or the client. The application often includes them to provide their income as well as expenses. They want a full rundown of like their rent, mortgage payments, utilities, credit cards, and other debts. So I'm always available to help them just itemize or go through what they have in order to get these applications completed. You also want to ask the hospital or your medical provider how long it takes for them to process the application. Some applications can be processed, within a week. Some take forever, or some just sit in like a waste bin somewhere, not being processed at all. So you want to, make sure they have a timeline in which your application will be processed and when you will know whether or not you are eligible for financial assistance or if you've been denied for financial assistance. When you are seeking financial assistance, it is best and it is pertinent that you notify any debt collectors that you are seeking financial assistance for the bill. You want to follow up with the provider about the status of your application. I would call them maybe like every week or every couple of weeks to make sure that they are really reviewing your application thoroughly. Even if you are being contacted by a debt collector, ask the debt collector to pause any collection actions while you are seeking financial help through the hospital's program. That is something that you really want to do because, as Lindsay explained, you are protected through some of these recent medical laws that were just recently passed in Maryland. Though things that nonprofit hospitals must do in relation to financial assistance is one, they have to tell you about their financial assistance policy. It has to be on their websites. It has to be in plain language. Their application forms have to be readily available. You can find them if you go into like the emergency room, if you go into any of their administrative offices, wherever you go in the hospital and you ask for a financial assistance policy, someone should be able to point you in the right direction to get it. These applications should be made available to you or your client at no cost, both in electric form and paper copies if necessary. They have to tell the community about their financial assistance policies, as well as they have to tell all of their patients about the financial assistance policy, those who may be eligible and those who are just inquiring about the financial assistance. All right, so earlier this year, well, the beginning of this year, the federal government passed a law called the No Surprises Act that went into effect January 2022. This protects you from surprise billing um, if you have a health plan or a group health plan or individual health insurance coverage. And it also bans surprise billing for out-of-network providers without prior authorization. It bans out-of-network cost sharing for all emergency and some non-emergency services, as well as it bans out-of-network charges and balance bills for supplemental care like radiology or anesthesiology by out-of-network providers that were in an in-network facility. In addition, the No Surprises Act requires hospitals and some medical providers to disclose federal and state patient protections against balance billing, as well as setting forth complaint processes with respect to violations of the protections. If you do not have health insurance, the No Surprises Act also requires hospitals or some medical providers to provide you a good faith estimate of how much your care will cost before you get care. If the bill is estimated to be like $600 and then you get a bill that is $1,000 or more, you have the ability to dispute the charges through a patient provider dispute resolution process that the hospital or the medical provider is supposed to give you information about, because essentially that is considered a surprise bill. All right, so some final tips when you're dealing with medical debt during or prior to it going to collections is one, make sure your client or you or your community partners avoid scammers. This is also a really hot spot for scammers to try to convince people going through medical bills that they can resolve all of their medical bills and remove it from their credit reports. That's not necessarily true. You do not have to pay a person who promises to help you keep your medical bills off your credit report. A lot of us advocates and attorneys at nonprofit legal organizations will help your client or help you do this for free. So you don't want to pay someone to do that for you. You also want to steer clear of people who charge you an upfront fee for resolving your debts and credit situations. And again, if you are receiving, medical bill debts from people you don't necessarily recognize, you want to ask that debt collector to verify the debt and provide you with information about the collector and the bill that's being collected. So that is all of the information I have for you for medical debts prior to collections and during collections. So our next speaker will be Mary McGuest, who talks about what happens after a judgment is entered in favor of a hospital for medical debt.
Thank you, Asia. Sorry about that. As Asia said, my name is Mary Miguez Jordan. I'm the managing attorney at Civil Justice. We're a member organization. We deliver legal services to Maryland families. While we promote a statewide network of attorneys, solos and small firm attorneys who are committed to increasing access to civil justice. What makes us stand out a little bit from other organizations is that a majority of our clients typically make too much to qualify for free legal help, or they can't be assisted by other legal services organizations. Now, we have a grant actually right now where we are working with patients who have medical debt and trying to help them resolve that. So the patient was billed, the hospital filed in court, and they got a judgment against them. What happens next? In many ways, the judgment collection that is allowed is very similar to any other post-judgment action. Asia, if you could go to the next slide. Maryland hospitals are required to proactively screen the patients. We've already heard the other presenters talk about that. But Maryland gives patients 240 days, and this is very specific, after the initial bill is provided. Now, the lawyer in me says, does provided mean when they were billed, when it was mailed, or when they received it? but the legislation says after the initial bill is provided. So no doubt at some point, someone's going to be at 241 days, and someone will have to define what that means. But they have 240 days after the initial bill is provided to qualify for financial assistance in the case their financial circumstances worsened after the hospital care. So they don't just have to have been in that situation at the time. If things get worse for them, that's why they've kind of put this in here. What's interesting is this is the first law of its kind in the country. And as I believe Lindsay talked about, the hospitals have to go back and review from 2017 to 2021 for patients who may have qualified for this care and they weren't afforded it. And right now it's estimated that $200 million is expected to be returned to low-income people. So it's very important that this legislation go. Excuse me. So what are you going to do? I want you to, well, obviously we're going to check the initial bill, as Asia told us. Make sure that the initial bill that is the basis for the judgment that's been entered against your client. Check to see if any adverse information has been reported to the credit bureau when it wasn't allowed to be. Pull their credit report. Annualcreditreport.com allows anyone to get 3 credit reports free every year. So I'm always telling clients, pull your credit report. Let's see what's on there. If the patient is later found, after the judgment is entered, and the patient is later found to have been eligible for free care, the hospital is actually required under the statute to vacate the judgment and strike the adverse information that may have been reported to the credit bureau. Next slide, please, Asia. These cases are primarily brought in district court because of the amount of money. Once a judgment is entered in any judgment in district court, you have several options. One is to request a new trial. You have to file a motion. The form is referenced in the slide. It's Form DC-002. That's helpful for pro se advocates or attorneys who just don't have the motion in their files. When you request a new trial, you can file that motion within 10 days after the date the judgment is entered. You have to state in writing the reasons you believe that the district court made a mistake. When you file the motion, you're basically saying the judge made a mistake. So something to bear in mind is that generally the same judge who heard the case will be ruling on this motion. So I say choose this one wisely. In 20 years of practice, I have never filed to say the judge made a mistake when I knew that judge was reviewing the case. You can ask the court to correct the judgment. You can file a motion to alter or amend the judgment again, that's within 10 days. And if the court denies your request, you can still file an appeal within 30 days. Generally, that's used to correct clerical errors. The last motion you can file is asking the court to cancel or change the judgment. You can file that motion to revise or vacate, cancel the judgment within 30 days after the judgment is entered. The motion is usually, again, filed to correct clerical errors, so it gives you extra time if you didn't hit it in that 10-day mark, or to vacate a judgment if you believed the patient was not served with court papers, so they were not notified of the court date. So this would be used more for like an affidavit judgment, affidavit judgment that's entered. But I have used that. That's actually pretty helpful. Asia, can you go to the next slide, please? As many of you know, if you get a judgment in district court, you have the opportunity to appeal to circuit court. Either party can appeal this case, and then it's in front of a different judge. You have 30 days after the date the judgment is entered to file your appeal. If you filed a motion for a new trial or to alter or amend, the 30 days doesn't start tolling until that you get an answer on that motion. There are very specific forms, and you can go to the Maryland Judiciary website, or to the court's website and find district court forms. The civil appeal form is Form 037. It's DC-CB-037. And the reason that's important is because it has little boxes that you check off that has to be filed with your appeal. If the appellant is indigent, you can seek a waiver of cost because it's not free to file an appeal. You can request a waiver of prepaid costs for assembling the record for an appeal, meaning the transcript. If the appellant is represented by Maryland Legal Aid, an attorney or other eligible legal services corporation, they are exempt from filing the fee, but you have to check the box. If you choose to appeal your case, remember that it's either a small claim or a large claim, and that's based upon the amount filed in the claim initially, not on the judgment amount. If you file a small claim, the case will be a small claim appeal. The case is heard de novo. That means it's all new. The judge is hearing it as if it didn't happen in district court, and you can actually bring in new evidence. If it's a large claim, and that's anything that's $5,001 above the record appeal, then no new evidence can be brought. It's only for errors. Next slide, please, Asia. What can a hospital do when they've gotten this judgment and they can collect on it? Lindsay already covered some of the things that they're not allowed to do. They may no longer force a foreclosure or a sale of a patient's residence. They may no longer request a lien on the primary residence in their action. So sometimes if you do collection work, you'll see that sometimes they will request a lien on a residence if they get a judgment. The creditor will. They may no longer request that. They may not hold a spouse or any other individual responsible for the debt. That's really important when you get to things like garnishments. After the 10-day stay, if you don't file any of those motions, or the 30-day time to appeal has passed, and generally in my experience, judgment creditors will wait till the 30 days run because they don't know if you're going to appeal. The hospital may now begin collection efforts. Some of these collection efforts are like any other judgment. They can garnish wages, they can garnish a bank account, they can seize other personal property, but they cannot seize or attempt to seize the primary residence. If they file a garnishment of wages, you have a right to contest it. You can file a motion to explain your defense or your objection why they should not be able to garnish wages. Once the garnishment begins, the creditor must send you a statement of the payments, and they have 15 days after the end of each month to send these statements. I think Lindsay already went over the amount of money that can be withheld, so I'm not going to repeat information. The other option that creditors have is to garnish a bank account. This becomes problematic for people because you have several exemptions that are available to say to the judgment creditor, say the court, this bank account may not be garnished. When you ask for an exemption, if the creditor has already taken money out of the bank account, that exempted money will be returned. So what can't be garnished? Well, under Maryland law, and this is in Courts and Judicial Proceedings 11-504, B5, anybody who practices in the world of bankruptcy, you use this all the time. You can request an exemption of up to $6,000 for any reason at all. The first $6,000 in my bank account cannot be garnished. And here's my motion. Here's my objection to the garnishment. And any money that had been taken will have to be returned. But there are other reasons you may qualify. Your client may qualify for an exemption. If the money coming in is Social Security benefits, disability or retirement, veterans benefits or other federal benefits, child support cannot be garnished. State public assistance, SNAP, TCA, cannot be garnished. Qualified retirement benefits, 401k, IRA, pension, they cannot be garnished. Workers' comp, unemployment, alimony, all not allowed to be garnished. But you are going to have to set that objection forth. The bank may or may not, once they get service of this notice of garnishment, it's really not their position to tell the judgment creditor, you can't garnish this money. It's the position of the garnishee. Anything that's considered spousal property. So for example, if there's a bank account, has two people's name on it, the people are married. This is very important. They must be considered legally married in the state of Maryland, and the bank account had to have been opened prior to the judgment being entered. If all of those things are there, none of that money can be garnished because it is now a joint account. Even if, arguably, they could trace what money was coming in, it's a joint account. So it's considered marital property and it can't be garnished. If you believe that your client's bank account has been garnished improperly, you file a motion for release of property from levy or garnishment. There's a form for that on the district court site. When you fill out that form, you're asked to describe the property you wish to have released from garnishment. Be very specific. List the name of the bank, the type of account, checking, savings, whatever. The last 4 digits of the account number. Don't just say bank account. If you're requesting an exemption for up to the $6,000 as permitted by Maryland law, there's a box that you check that says the judgment debtor elects to exempt property of the value allowed by law. You might think that this is unimportant, but remember that's going in front of a clerk. And if the boxes aren't checked, they may just kick it back out. For most exemptions that I've given you, you're just going to list other and write what it is. Social Security, disability benefits, child support. Submit to the court this form within 30 days of when the bank was served with the garnishment. When the bank is served, your client, and if you've entered your appearance, you will get a copy of this. If you are an advocate where you're not entering your appearance, but you're helping the client get through it, remind them they must give you these documents when they come in, because if they don't and you miss that time, you're out of luck. When you file your objection, be sure to serve it on all the parties. A judge will review the request. Sometimes a hearing is held, not usually. If it is, though, appear at the hearing. Make sure your client appears at the hearing. Next slide, please. Oh, I'm sorry. Nope. Really quick. What a hospital may not do, again, as Lindsay already went through, they can't get a lien against your residence. I just want to be clear about that, because one of the tips I give a little bit later is check land records. The reason I say that is in Baltimore City, it's unique to Baltimore City. When a judgment is entered, the clerk automatically, for many, many years, has sent a notice of judgment to land records, and it automatically puts a lien on any real property owned within the city limits. I was in another organization discussing this, and I brought this up, and someone who had worked on the statute said, we're looking at the implementation issues in the next session. That's fantastic, but it may not help our clients in the meantime. So check land records, make sure nothing has been enrolled, especially in Baltimore City. Next slide, please. How do we help our clients post-judgment? There's a judgment entered, everything is correct. There's not a lot we can do. One, figure out if the client was served. I actually have a client right now who has a judgment against them. They were never served with the court date. Because of COVID, the court dates got kicked and they never got notice of this new court date. We're filing a motion to have that judgment vacated. If you can't do that, if everything else is correct, negotiate a lower amount. Negotiate down. If the client has access to lump sum. Now, I will say creditors, when you negotiate a lower amount, sometimes they'll break up that lump sum in, say, 3 payments. But for example, if the debt is $10,000 and your client has $6,000, you can offer that as a lump sum payment for full and final satisfaction of the debt. Bear in mind, when we settle debts, the client is oftentimes 1099 on the balance of that debt. So in the $10,000 case, if you offered $6,000, they would get a 1099 for $4,000 of imputed income. I don't give tax advice, but I do let my clients know that so they can talk to their accountant about how that might impact them. The other option is you offer a lump sum payment, but you ask to break it up over 3 payments. And finally, they get into some sort of payment plan with the creditor. Next slide, please. Thank you. I can't emphasize this enough. Asia was very clear on one of her slides about checking to make sure that the patient had actually received the services for which they're being billed. We had a client billed for kidney stones that they never ever had. Check everything. Check the creditor's calculations. Hospitals are prohibited from charging interest on bills incurred by self-pay patients. I think Lindsay said the uninsured. Hospitals call them self-pay. They're prohibited from doing that before the judgment's obtained. Check their calculations. Check the little form that they filed with their complaint. Make sure they're not doing that. Oftentimes, especially when the law is new like this one, it's not that they're trying to be sneaky. It's that there are paralegals who've been doing it this way by rote, and they don't necessarily change the way they're doing it. So just check the calculations. Hospital may not charge interest or fees on any debt incurred after the date of service by a patient who was later found to be eligible for free or reduced care. This matters. If they're applying for free or reduced care, perhaps not through the hospital, but some grant, you want them to have to apply for the least amount possible. So check their calculations again and again and again. Next slide, please. The law is new. We're all kind of learning it as we go. These are I have listed some, not all, organizations that can help patients in this position. Civil justice, the Maryland Court Help Centers, oftentimes will help people file a response or a motion or a notice of intent to defend, so they have time to get an attorney. The Debt Collective has amazing information. Maryland Legal Aid, Maryland Volunteer Lawyer Service. When I was in private practice, I worked with Maryland Volunteer Lawyer Service. It's a wonderful organization. And we oftentimes help people pro bono. Public Justice Center is another one. So don't be afraid to reach out for help, either for the client, if it's outside your purview, if they need free services and your pro bono is done. I was a solo, so you only do so much pro bono a year because you still have to pay the bills. If you've reached that limit, send them to these organizations, or if you have a question, we are happy to help. If we don't know the answer, we will try and find it for you. Next slide, please. All right, I talked about this a little before. Practice tips. Get their credit report. Get it before the case and after the case. See how things are reported. Check land records, specifically Baltimore City. Assist your clients with the charitable application. You might, as attorneys, sometimes we feel like once the case is finished, our job is finished. But the truth of the matter is, if we're dealing with this population, and anybody who's here is willing to deal with the population who's having these debts, we also have some social work that we have to do. We need to help them with these applications. They're not easy. I have one that one of our attorneys in civil justice had their office fill out. They completed it. The client signed it, and it was kicked out by the hospital because a box was not checked. So I really can't emphasize enough. We can't just hand them the application and say, here you go, apply for charitable services. We need to be helping them through the process. If you settle a claim, if you negotiate a lower amount and there's a settlement agreement, if you believe that the client has other claims against the hospital, for example, review your settlement agreement for waivers of all claims. This is SOP language. When we have a settlement, we always put a waiver of all claims in it. But if you believe there's other potential claims out there, you want to make sure that settlement agreement only speaks to that debt that you're settling. Next slide, please. This is just our basic thank you to everybody involved. These folks have worked really hard, including myself, Asia, who has put together the slide presentation for us and moderated, Amy, who is part of Maryland Volunteer Lawyer Service, Bridge, who's at the United Healthcare Workers. She had amazing information for us. Lindsay, who did a great job, myself, and our executive director at Civil Justice, Sarah Coffey-Bowes. If you have any questions, our emails are on there. Please reach out to us. We are happy to help in any way we can. Thank you.
So thank you everyone for joining our webinar this afternoon. Of course, if you have any questions, please feel free to put them in the chat, or you can put them in the question and answer box. Of course, MBLS always has free recorded trainings available on our website in a variety of categories. Also, make sure to follow us on our various social media accounts. I do not see any questions in the chat box or in the question and answer box. Mary or Lindsay, do you have anything else you would like to say to our guests?
I mean, I would just like to say thank you for sort of taking the time to be with us and sort through what is a lot of really dense information, but really important information. And I want to reiterate what Mary said. These are complicated processes, like for patients, for debtors, but also for attorneys. And so if you have questions, just again, please feel free to reach out to any of us. If you encounter violations of what we've just sort of explained is law, again, please feel free to reach out to us and we can help you sort of direct those violations to the appropriate regulatory bodies and ensure that something is actually being done to address them and to ensure that they don't happen again. Because again, like Mary said, it's not necessarily a sort of deliberate choice to violate these protections, but it's, law is complicated, new laws are complicated, and people who are used to doing things a certain way within these institutions often don't know that these changes have happened. And we need to make sure that, a lot of groups worked very hard to win these protections. We need to make sure that they're actually being respected and put into place. So thank you everyone. And again, we're all here if you encounter anything that you'd like to talk about.
All right, thank you all again for joining us at NVLS's medical debt training webinar. I especially want to thank Mary and Lindsay for joining me this afternoon, and I hope the rest of you have a good rest of your day. Bye.